All right, not currently used. So why am I spending so much time in this? We have begun to see in the charging documents in the immigration court that the file was actually started out as an expedited removal file. So the officers used the forms for expedited removal. They've conducted the interview as if it's going to be expedited removal. And then because it is a young mother with a child, or because it is a teenager that they realize is a teenager, they flip the case from being expedited removal to being removal charging you're inadmissible. But sometimes not everything in the file gets transferred over. They move too fast, they're a little bit sloppy, the data in their computer system may still indicate the case is expedited removal. So you've got to learn to look at what those forms are, and it's not hard to figure that out. You can go onto the Asylum Officer's Handbook. You can read what the forms look like. You can go onto the regulations. They're found in 8 CFR Section 235. They're very detailed. And if you are looking at a charging document or you get a file, as Desiree is going to tell you how to do a FOIA request, and you see expedited removal was originally part of the process, you have to be ready for shadows and vestiges of complexity that may arise from that situation. I'm training you today, it doesn't exist, it may exist on Friday. Of course, if it does, we won't see these children, and I'm going to talk about that again in a second. Number two, removal based on charges filed at the border. That means the government is saying we are going to physically let you into the country, but we're arguing that you're inadmissible, and removal based on charges filed within the interior. That could be they've apprehended a child here in New York, or a child's been in some kind of workplace raid, or maybe has even been involved in the criminal area, and they're now being charged with being deportable. So, I'm sorry, I forgot to click my slides. I forgot I even made them. Expedited removal, Section 235B, I already mentioned that. It could be at any international port of entry, so it could be O'Hare in Chicago, it could be JFK. It has to be these two grounds: inadmissibility found under misrepresentation or fraud or lacking documents. But after the events of 9/11, the Attorney General expanded the scope of expedited removal twice. Once for people who arrived by sea. So if you've arrived by sea within the last 2 years, you can still be subjected to expedited removal. Of course, I always joke with my students, are you still wet and salty? Like, how do we know who arrived by sea in the last 2 years? Well, probably because you've admitted that. Or people who are within 100 miles of an international land border. Now, New York City is within 100 miles of an international border, but it's a sea border. But if you're up in Rochester, you're within 100 miles of the international land border. If you're in Detroit, you're within 100 miles. If you're in Tucson, you're within 100 miles of the international border. So expedited removal can be used on individuals who are apprehended within the country. Now, I mentioned already that children, there's an exception, and in the article that I believe we distributed before, we cite that the exceptions are found in the regulation. Another exception, expedited removal, is a person is a citizen, returning LPR, or was already granted asylum or refugee status. So obviously when we're doing our screenings, we look for that as well. But there's no way to challenge expedited removal. The statute specifically says there shall be no administrative or judicial review of the decision of Customs and Border Patrol to expedite removal, to order removal. So if it's wrong, if your kid that you're representing now is 17 years old, but they thought he was 19 years old, and they subjected him to expedited removal, and in his FOIA file, in his file, immigration file, you see there's an expedited removal order, how do you collaterally attack that order? Well, technically, there's no direct appeal. There's no direct administrative challenge. There's no direct federal court challenge. There is in the statute a limited habeas challenge, again, for citizens, LPRs, and returning asylees and refugees. There has been some success recently in the Ninth Circuit where people challenged it as a due process violation because the agency failed to follow its own rules. But here in New York, I know that, believe it or not, Customs and Border Protection has been responsive to legal briefs written to their district director to give a history of why expedited removal was erroneously used. And so you're basically going to put in the affidavit of your client, corroborating evidence, and if, for example, the client articulated a credible fear but never got a credible fear screening, if the person was under the age of 18, if the interview was conducted perhaps in a hostile, violent, dangerous situation, maybe you could argue for the agency itself to rescind the expedited removal order. If you can get that order rescinded, then really there is no need for a removal hearing. The person could just be reinstated and removed again. Worse, you should know that there could be a criminal proceeding brought against your client for illegal reentry. It is unlawful to enter the United States. It is a potential felony if you reenter after an order of removal, and expedited removals count. So the federal public defenders represent people in those criminal cases, and they have had some limited success in also attacking expedited removal. Again, it's not for, I'm proactively training you. The children have not been subjected to expedited removal, but they might start being subject to that next week. Okay, removal and admissibility. This is really the posture one doesn't want to be in, where the government is alleging, it's as when you're before the immigration judge, it's really as if you're still pleading your case at a port of entry, at the border. And what you're saying is, the government's wrong in saying I'm inadmissible, I really should be allowed in. Well, if a child is coming without parents, without documents, without a visa, they really are inadmissible, aren't they? But the burden is on them to prove they're admissible. And those of you who know immigration law know there's no generic waiver of document requirements of passports and visas for children. So when you're in this situation where the government is alleging that if this is the only allegation they make, that you lack documents, it's probably truthfully accurate. You probably are inadmissible, and it may be, depending on what Rex Chen teaches you, oh, Rex left the room, sorry, tell Rex when he gets back, that you're going to concede that the child is inadmissible and seek relief. Now, for adults, sometimes, however, the way they write up the charging document, there's other errors. And so one might potentially make arguments about even the errors in the charging document and not admit the allegations by saying they're erroneous. And this issue of you bear the burden of proving admissibility is true, but you don't bear the burden of making their allegations. So if their allegations are full of factual and legal error, you can still contest those allegations. Claire has been telling me, she's been reviewing the NTA, she's starting to see likely to become a public charge being alleged a number of times. Because they're unaccompanied child. Well, if they're being reunified with grandmother, mother, dad, aunt, brother, uncle who are able to support them, and when they were released from ORR, they did an affidavit of support showing they support them, you can certainly contest that allegation. And you can rebut and prove that allegation's not there. But I have to say again, most of us just concede removability for being inadmissible and move on to relief. However, be careful. If your child is a returning child, like they were here before, or maybe they were apprehended in the interior, sometimes the government will charge you're inadmissible. You really should contest that and make a motion to terminate and instead say, I'm actually not at the border. I made an entry. And this is an old case called Flutie. We call it the Flutie Doctrine. You know, when have you sufficiently made an entry? The statute says entry is inspected and admitted, but sometimes you're someone who is re-entering after a prior inspection and admission. That's an advanced topic. I don't know, Rex, if you're going to get to talk about Flutie Doctrine. I doubt it. Here's what I always say to my students, so you know I'm really hyped up about it. Interview your child if they have lived here before, if they have lived here a period of time, and this happened to be a return. Let's talk to me about it, because I tell my students we all need a tattoo somewhere on our body that says Flutie lives. Now, I don't happen to have a tattoo because I'm chicken.